Right, I think we're okay now. We're hearing our case 1CACV 17-0515, Becker versus Liu. Each side will have 20 minutes to present an argument. Appellant, you may reserve as much of the time as you wish for rebuttal, but you'll have to keep track of the time yourself. We have a clock at the podium for that purpose. We are recording the argument, so in a few days you'll be able to watch the argument on YouTube. Because we are recording the argument, please identify your client and yourself when you begin your argument. We've read the briefs and the record. We've conferenced the case. We're familiar with the facts and the issues. So when you begin your argument, just launch right into what you would like for us to know. Counsel, you may begin.
Thank you, Your Honors. It's an opportunity to be here and speak for my client. My name is Stan Martineau, and I'm here to speak for Ruth Ann Becker, who is the personal representative of the estate of Luigi Rosa, now deceased. He was the original plaintiff in the case. And I'd like to begin today with just a couple of house cleaning items. One is our appeal brief, the second page of it, the table of contents, is in error. The argument headings don't match the argument headings in the body of the brief. That's what counts. Those are what counts, not the table of contents. That was an error, which I apologize for. The court is already familiar with the basic facts of the case. It's a lawsuit by a hired house sitter against homeowners, and it originated by an occurrence when they were on vacation after about 15 days, and their dog tripped this house sitter, caused him to fall, fracture his neck, left him a paraplegic with over $1 million in expenses, and ultimately he died.
Everyone agrees on those facts?
No, of course not. There are disputes. What I did not intend to do, unless the court wants me to, is to address an issue raised in the appellate or the appellee's answering brief, in the Liu's answering brief, which is that there's no credible admissible evidence that the dog actually tripped my client. I'm going to rest on what's in the briefs because I don't think this is the time or the place, or frankly the court, to have that issue decided, because it's a Rule 803. It's a balancing of different evidence to determine whether or not the hearsay statements.
Facts and the most favorable to your client for today's purpose.
Okay, thank you. So what I would like to do actually is to focus on what I think are the equities here. I want to start by talking about why we think it is fair for the homeowners to be held strictly liable for my client's injuries and damages. And to do that, we need to go to Spurlong versus Brown, Court of Appeals opinion. The Spurlongs were the parents of a little boy who was bitten by a dog that escaped from the backyard of a man named Brown. The dog was actually owned by a gentleman named Mays. He rented a couple of rooms from Mr. Brown about 3 months before the incident happened, and he and his live-in girlfriend moved in. They lived in the house, and they took their dog, Jupe. On the day in question, Mr. Brown was gone, and Mays asked his girlfriend, Russell, would you want me to leave this dog, Jupe, out of his cage so that he can keep you company? And she said, sure. Later in the day, she took the dog to the backyard. Sometime during the day, the dog escaped from the backyard, ran down the street, and bit a little boy, the son of the Spurlong. So that's how the case originated. The Spurlongs sued Brown as the owner of the home, Mays, and Russell, the three defendants. Mays and Russell defaulted, and so the case really centers on what happened with Mr. Brown. They were arguing that under ARS Section 11-1001, Subpart 10, that he should be deemed the statutory owner of the dog. And if that's the case, then he would be responsible under the two statutes, dog injury statutes, that the Spurlong sued under, which is ARS Section 11-1020 and Section 1025, the dog injury and the dog bite statutes. Brown said, no, I didn't have anything to do with the dog except I provided a place. The Spurlong said, no, that's enough under the statute. The statute says that any person who keeps, term of art, keeps a dog for more than 6 days is deemed to be the dog's statutory owner for purposes of all of the dog injury statutes. The Court of Appeals agreed with Mr. Brown and said it's not enough. Whatever he did is not enough. What is required is the person must keep the dog, and keeping means exercising care, custody, and control. The court elaborated on that and said this means exercising proprietary control akin to ownership, meaning the question is, did Mr. Brown actually exercise almost ownership type proprietary control? The court said no, there was no evidence of that. This is what I want to read about the equities and why this is important. This is a very important point to me to start with because it helps to inform our analysis in the rest of the case. So the court in Spurlong quotes a decision out of Michigan, the Traeger versus Thor case, which is, the quotation is in the case. I'd like to read a little bit of this because I think it's very helpful. The court said that to be equitable, strict liability for dog bites, and in Arizona that includes the dog injury statute 1020, which we're concerned with here, should not be imposed unless the liable party has been given an opportunity to assess the potential risk posed by the dog. And then going on, now this is the quote. In order for such allocation of strict liability to be equitable, the liable party must have sufficient custody and sufficient control of the animal to assess whether a risk is presented by an abnormal propensity and to decide whether an animal should be brought into or remain in the community. So what's the risk? The risk is that dogs, unlike humans, cannot conform their conduct to a reasonable man's standard. So in this case, Kona trips Luigi. Kona could not say, I better not run up behind him and get in front of him, get tangled up in his feet, because he might fall. He doesn't know I'm coming. He doesn't know I'm here. She can't do that. In fact, no dog can, and animals cannot.
Well, that may be an overstatement. There are assistive animals who are pretty highly trained in that regard, but all of these stories about dog bites seem rather inapposite to me when the mechanism of injury here is alleged was no different than could have been caused by a human walking through an airport. Or this is not a bite. This is not animal behavior. The decedent here, as tragic as the injuries were, tripped over an object that happened to be a dog, but could have been a child or an adult or a box. And I'm struggling to see what the aberrant propensity is, or what the owner, assuming that they were keeping and harboring the dog, should have done besides hiring a dog sitter.
In order to not get a field of the arguments we're trying to make, we have to stick very closely with the theory that we're concerned with. What I'm talking about right now at the beginning is ARS Section 12-1120. Negligence has nothing to do with it. It has nothing to do with the case, nor what the owner knew.
Well, we've talked about a couple of your bases, and we're talking about equities. If we're now going to talk about statutes, that's probably a good thing to do, because the statutes don't speak of equities.
Well, the statute imposes strict liability, Your Honor, and this is the reason, that the historical reason why dogs have no commercial value. I don't think the Liu's made a nickel out of owning this dog. I mean, they can, but in this case, it's a pet. So the law has been historically that if you want to buy a dog, you want to introduce him into the community, realize that you are an insurer under the statute of the dog's conduct and behavior. And if this dog injures someone, then you're responsible. Strict liability. Doesn't matter what you did, doesn't matter what you know.
So if the dog happened to be lying asleep and someone tripped over them, then they're strictly liable for that?
I don't believe so. That's not the facts of the case, because in our case, the dog tries to get around him and actually gets entangled in his feet and trips him. A dog lying there isn't doing anything that causes anything. I mean, that would be like a skateboard that a child leaves on the floor. The difference is that the dog keeps moving around, whereas a skateboard or any other object is stationary and the person can avoid it.
Does that make the dog dangerous? That it was
Well,
moving around?
that's one of our contentions, but that's not necessary for the statute. For the statutory strict liability to be imposed, all that we have to show is, and we haven't got there yet, but we have to show that the dog was not confined by its enclosure and that the owner was responsible for that dog. Those are the two criteria in the statute.
And it was moving, I guess. Because if it wasn't moving, then there'd be no liability.
Well, that's a good question, but those aren't the facts here, because the dog was moving and the dog physically moved into his path the way the dog had done many times in the past, according to his story. So the point is, the dog's conduct, active conduct, caused this man to trip and to fall.
Which isn't exactly what the statute says. The statute says injury by a dog, which seems perhaps not to include any chain of events placed in motion by a dog.
It seems like the dog may have been the occasion of the injury, but the dog itself is based on argument that the dog injured the client. I mean, the impact on the ground is what injured the client.
Well, you can't exclude or ignore the fact that the dog tripped him.
Well, what if the dog is kind of a messy eater and goes to eat from its bowl and spills water on the floor and a couple of chunks of dog food, and your client trips on that? Has the dog injured your client?
Well, the dog created a dangerous condition on the premises, perhaps.
Is that a guess? If the dog is a messy eater, that's sufficient to cause strict liability?
Well, I think so, but we don't have any cases that even come close to that.
Well,
I mean,
this case comes close to that, because we're talking about the dog qua object, not the dog qua dog with teeth and claws that sets out to injure somebody. We're just talking about any chain of events that might arguably be tortiously begun by a dog. So if the dog creates a mess on the floor and somebody slips on it, that is equivalent to a bite under the statute in your view. Is that right?
Well, they're two statutes. They're completely different. And
Well, I'm talking
typically,
about the one you were talking about, 11-10-20.
right, but this, okay, and you're
So let's
comparing
talk
that
about
to
that one.
1025, which is the bite.
Okay, but tell me which statute you want to talk about.
1020.
1020. Okay.
11-10-20.
1020. Is it your contention that a dog who makes some sort of a mess on the floor and sets in motion a chain of events that causes injury is a dog who has injured a person under the statute?
The statute, let's just go to the statute itself. Injury to any person or damage to any property by a dog while at large. That's causation. That's just fundamental, normal causation where the dog triggers an event that causes injury to somebody else. So the dog can walk in front of somebody and trip him. The dog can jump up on him and knock him down. That's the Drake versus Dean case that was cited.
It's tough to be a dog then, because if a child did exactly the same thing, there wouldn't be liability.
Well, of course.
Okay. So I understand then. That's your construction of that statute.
Can I make a comment, Your Honor? Sorry for interrupting, but you said it's hard to be a dog. No, dogs don't have a standard that they live by. It's the owner that has the risk, the potential risk of incurring strict liability for all harm his dog causes. That's the point that I'm trying to make. And that's why it's fair, because if you bring a dog into the community, you buy a pet and you say, I'm going to bring this pet home and I'm going to introduce him into the community, the legislature apparently believes that any harm that dog causes, you are strictly liable for.
Strangely, if I bring a tiger into the community, I'm not subject to that same liability.
But there's no specific statute. No, correct.
So if an owner is walking his dog down the sidewalk, the dog relieves himself on the sidewalk, and the person carries forward without taking care of the material, someone walking behind him doesn't see it, slips and falls, can sue the owner of the dog because the dog caused the injury.
Well, these hypothetical circumstances are difficult to know how to deal with. Those are not our facts, but I understand the issue, the point. First of all, well, that's a good question. I don't know.
I understand that those are our facts, but we're in a public court, so we're not dealing with just these facts just to solve. We have to, consider what efforts our ruling might have.
Our fundamental argument is that it must be injury caused by the active conduct of the dog, and as I said in our brief several times, once the dog owner if the dog owner introduces the dog into the community, which in our position is they occupy the same space.
So they're at home.
Yes.
So your position also must be that any dog who is in a house is at large if the dog isn't kept on a leash in the house.
Yes, it is our position. However, it doesn't make any difference.
That should say at large. What's the point of saying? Why don't they just say any dog, anytime?
Well, because it says at large is defined. At large is defined to be confined by an enclosure or restrained by a leash.
Okay, and a house is not an enclosure?
Well, that's the question, and that's the point. For example, if someone brought a seeing eye dog in here in this courtroom and turned it loose, it's in an enclosure. But wouldn't the statute, because it's the walls of the courtroom, enclose it? However, the purpose of the statute, which I was reading from Spurlong, is to shift the economic losses that can occur because a dog cannot control or conform its conduct to a reasonable man's standard to the owner that made the decision to introduce that dog into the community, and in the case of a home.
The community here. The community was a locked home, and the injured party was somebody who was hired specifically to ensure that the dog made it through the trip okay.
Well,
how much less at large can one be?
The problem, if we keep going back to the word at large, that evokes an image of a dog running down a street.
Well,
but the point
it evokes an image of what's in the statute. It says, and the statute applies to a person injured by a dog while at large. So I'm not trying to be overly visual here. I'm just trying to interpret the statute the way it's written.
Well, but you have to also look at Section 11-1001 that defines at large to be not confined by an enclosure, confined by an enclosure, or not restrained by a leash.
And a house, in your opinion, is not an enclosure?
Not as soon as the owner invites someone to come into his home, that person is now at risk from the conduct of this dog.
Doesn't invite the person. What if you have a dog at home who's a watchdog? He's sitting quietly watching TV in the house with the doors locked, and someone breaks in, and the dog attacks him. Does the statute apply?
Well, no, because the person would not. Well, if it's a dog bite, first of all, the person would not.
It says injury to any person. It doesn't say image to good people. So if you have a burglar come into the house while the dog is sitting there minding its own business, and the dog responds to the burglar by attacking the burglar, does the burglar qualify as any person who now gets strict liability damages?
Well, no, because that's probably going to be the rule applied by Johnson versus Svittergall, which is it's an intervening, superseding cause. The owner did not choose to let that person come in the house. They came in on their own, and I think that interrupts liability.
Any person. So if let's say now the dog is in the backyard and not on a leash, is the dog at large?
Yes, as long as somebody else goes into the backyard.
Okay, so somebody goes into the backyard, just steps over an unfenced backyard property line and is injured, uninvited. That person, I assume, qualifies as any person eligible to sue.
I don't know. I think that would depend on other facts, because what we're concerned with is, did this owner invite somebody into his home?
I just don't see where that's in the statutory language. Any person seems to me as clear as language can be.
Then does that make it ambiguous?
Clear because it's clear? It's ambiguous?
No.
An injury to any person.
Right. All these circumstances that we're bringing up includes the fact, or the hypothetical of a dog running loose in this courtroom, or a dog running loose in a 40-acre housing development that's fenced and he can't get out. If he's running loose in that development and injures somebody, is he at large or is he not at large because he is enclosed or confined by the fence? The point is that if we're going to interpret the statute, we must interpret it with reference to its purpose. And its purpose is to protect people from harm caused by animals that cannot conform their conduct to a reasonable man's standard. And the way that protection occurs is if that individual is injured, as was Luigi in this case, the economic loss, the risk of economic loss, is shifted to the owner of the dog, who decided to either bring the dog into the community or to invite someone into the same space. The point is, as soon as a human being and the dog occupy the same space, then the statute applies.
Thank you, Counselor. Your time is up. Counsel?
Good morning, Your Honors. I'm Christopher Bork, representing the defendants appellees, the Lius. With me this morning is my co-counsel, Michael Childers. If I understand appellant's argument that they just made, counsel just made, it seems to me that he's arguing that an owner of the dog, just by the very fact that they've decided to purchase a dog, have that dog as a pet, is strictly liable no matter what that dog may do, no matter where that dog might be when it does something, if it injures a person or causes damage to property. And that is not the law in Arizona, and it's not the law generally. It wasn't even the common law. There's an interesting comment in Restatement Section 518, which is the restatement section that addresses harm by animals not abnormally dangerous. It's comment J, and it says that normally dogs are not expected to do substantial harm. And it notes, in fact, that under the common law, dogs were allowed to run at large simply because nobody would expect them to do any kind of substantial harm. Apparently, as a society, we have developed somewhat, and now we have a statute that has changed the common law. But that's a very specific statute, and it doesn't change the fact that in most cases dogs are not going to be injuring people. And that comment also notes that typically owners don't have to keep a dog under constant control because it's not expected that your average dog is going to cause injury to somebody. Now, appellant is taking this to the point where they believe, I guess, that any dog is a danger to anybody, no matter where it is, no matter what it does, and that the court should crack down and make everybody strictly liable for their dogs. And that just seems unworkable in a society that, of course, is very fond of dogs and takes dogs to restaurants and parks and everything else.
Do you agree there is a difference between a dog causing injury and, as I put it, the circumstances of injury involve the dog?
Well, I think there is, and I think I agree with that, and I think the courts that have addressed this subject have kind of found the same thing. There's a California case, for example, called Drake, where dogs are just running around and they happen to run into a woman. One of them happens to run into a woman while they're playing and knocks her down and causes some injury. The dog, there wasn't an intention by that dog to attack the woman, go after her, focus its attention on that woman. It just happened to be in the same space where the woman was while it was playing. And so I think although those decisions don't actually make that distinction, it seems like a reasonable distinction, because even though dogs cannot completely control their behavior the way human beings do, dogs that injure people sometimes do have an intent to go after somebody, to bite somebody, to attack somebody, to jump up on somebody. But there is no evidence in this case that the dog did that. That it's simply a question of the dog and the human being kind of in the same spot, going for the food and getting tangled up in each other's legs. And unfortunately, we have a very tragic accident that resulted because of that. But
do you think the statute implies a distinction between active harm and passive harm? I'm trying to understand this statutory language where it says any injury by a dog. Presumably, this tragic accident could have happened if the dog had simply decided to go to sleep in an unexpected location, and the decedent had tripped over the sleeping dog. That strikes me as beyond what the statute intends. So when I suggest active or passive, are you suggesting that maybe the statute contemplates there has to be some intent by the dog?
No, well, I think, first of all, the statute, we don't believe that the statute even addresses this particular case, because it talks about dogs at large. And if you're looking at the standard language in that statute, at large, it refers to dogs running loose on the streets, not dogs in their own homes.
There's a dog running loose in a field, completely at large, decides to take a nap in the field, and somebody trips over it. Does that count under the statute?
That's an interesting question. I'm not sure of the answer. I mean, I know I've read somewhere of cases, maybe it's in the restatement, there's an example of a dog running into the street and causing a car accident. The dog didn't intend to do anything necessarily. It just ran into the street and there was an adverse consequence. But I think, for a legislature to pass a statute like this, to change the common law, they would have had some concern about what dogs might do when they are at large, running on the streets. Obviously, bites are a concern, although there is a separate dog bite statute. But it's hard to say. Jumping up on people is something that might cause injury. But it's just unclear from the statute whether the scope of it is to cover something as unusual as that. And of course, when you pass a statute that is in derogation of the common law, it's strictly construed. So I think if a dog is just sitting down somewhere and somebody accidentally trips over them, that would be very questionable as to whether that is a dog at large injury or whether, it's very similar to the same thing that you mentioned, Judge, that they could have tripped over a box or a hole in the ground or something else, because the dog is completely stationary in those circumstances. So the evidence in this case is certainly disputed, and as we've told you, and if you've seen from the record, there were a lot of facts that on summary judgment that were accepted without any opposition by the plaintiff at the time about what happened here. And to the extent that the only thing it comes down to is it's not an attack by a dog, it's not a bite by a dog, it's not viciousness by a dog. It's simply a dog getting in the way of somebody's feet. And from that, the appellants say, well, this dog had particular behavior characteristics that were abnormal or unusual that the owners should have known about and they should have trained him. And they carry that off to the point of absurdity that, this dog should have been locked away inside of a bedroom or locked away inside of a cage, and it should have had a doggy door so it could go outside, but if somebody went outside with it, it was suddenly at large, and then so if somebody goes into the room, it's at large. So whether a dog is at large under their version depends upon where the dog and where the person are positioned, and that can change constantly throughout the circumstances that exist here. But if we look at, there are really three theories that the plaintiff brought. One of them is this dog at large statute theory. One of them is that the dog was abnormally dangerous. And the other one is harm done by a dog that was not abnormally dangerous under under Restatement Section 518. And what the trial court found on Section 518 is that it was Luigi Rosa who was the possessor of the dog at the time of this accident. This was the 16th day of a 16-day house-sitting, dog-sitting period. He had cared for that dog without any problem for 16 days. He'd cared for the dog on 2 prior occasions without any problems. And suddenly this very strange and unusual accident occurs when he apparently gets tripped by the dog, falls on an exercise ball, bounces off the exercise ball, and then hits the floor. So we've got a combination of both a dog and an exercise ball being involved in this accident. And plus there are facts that tend to disprove that that's not even what happened. This story didn't even come out until almost 2 years after the accident.
That's not properly before us in reviewing summary judgment, is it?
Well, we do have this argument that there isn't sufficient evidence to support this claim. That was part of our initial argument that the appeal should be dismissed.
We're reviewing summary judgment, right?
You're reviewing summary judgment, yes. But it was one of our arguments that even if the court were to reverse on a legal theory, there would not be sufficient admissible evidence for this case to even go at trial.
That's far beyond what we can consider.
Okay. In any event, so if we focus on Restatement Section 518, the section doesn't even talk about what a dog owner has to be. It doesn't really explain. It just says if the owner is negligent in some fashion, then there can be liability, but there has to be some proof of negligence. And there's no evidence here that the Lius knew that their dog had any dangerous conditions that would have caused injury to this particular dog sitter. And the manner in which the accident occurred is not even what they were complaining about as these so-called unpredictable behavior patterns. The dog, first of all, there's no evidence the dog did anything unpredictably. They contend that he would want to play and get up around people's feet, but that's not what caused this accident. The dog wasn't playing, wasn't trying to get attention, wasn't running around people's feet. They contend that he had a tendency to jump up on people from time to time, but that's not what happened here. He didn't jump up on anybody. He simply was going for his food at the same time. He was hungry, and they got tangled up, and that's what happened. And if we talk about equities, it's not equitable to impose liability on a dog owner when an accident happens simply because a dog is being an absolutely normal dog. Normal dogs go for their food. They want to eat, particularly when a dog is being fed probably a couple hours late based on the evidence in this case. So there's no indication that this dog was doing anything unusual or inappropriate, and there's no reason that its owners would have suspected that it had any characteristics that would impose any danger upon Luigi Rosa when he was dog sitting. So that theory is just, it's without support, because none of the case law that I've seen indicates that courts have ever imposed liability on a dog owner for a dog acting normally like a dog. We don't have a lot of case law on this, probably from the fact that people don't bring cases when these kind of situations happen where a dog has just acted normally, or they don't get very far, or they don't make it to appeal. We have the Koweski case, which is a U.S. District Court case, where a dog at a dog park apparently bumped into somebody while in the process of playing and gathering around the owners. The woman was knocked over partially and was able to grab another person standing nearby her, but somehow still got hurt. The court essentially said, this is normal for dogs. When they go to play, they gather around their owners. They sometimes get in the way. They might nudge or bump into people, but that's not a basis for liability. And that's really all we have here, is a dog just acting like a normal dog. The argument that they've made that Kona was abnormally dangerous, the trial court found there were no facts that Kona was abnormally dangerous, and they haven't shown anything that would indicate abnormal danger. Even the worst case, based on the evidence they presented, is that Kona liked attention and got close to people. But there's no indication that Luigi Rosa found that to be a threat. He liked the dog. He was sitting on the couch with the dog for 2 hours, watching TV. He used to sing to the dog. Again, just normal dog behavior. So we move on to this dog at large statute again. The statute has to be interpreted reasonably. It has to be interpreted using the words in their ordinary sense and meaning. Dog at large means running on the street. It doesn't mean running around inside somebody's house. The fact that a dog is enclosed,
Is enclosed good enough, though? I mean, if a dog is running around the owner's house, I agree. Colloquially, we would tend to think of the dog as not at large. But if the dog is running around Terminal 4 at Sky Harbor, also in an enclosed space, could that dog not be at large?
I think under the circumstances it might happen if a court were to view at large as meaning a public space, an open public space where other people are.
I'm just trying to interpret what the legislature wrote.
Yeah.
At large, there's connotations of old westerns, but it doesn't tell you much about what type of enclosure might be required. Appellants would have us to believe that any time a human is in a space with a dog is at large. And while that may seem counterintuitive for a home, it doesn't seem that counterintuitive for a place of public accommodation. And yet the statute uses no words to help us draw that distinction.
Well, you're right about that. It doesn't do that, and I think it's up to the courts at that point to determine what's a reasonable and appropriate rule under the circumstances.
So the statute's ambiguous.
It's not ambiguous. It may just be unclear how it applies to particular unusual situations.
Do we have a plain meaning definition of the term at large?
The courts that we've cited from outside of Arizona say it's running around on public streets. It's not being inside your owner's home or on your owner's own property.
But if it's a statutorily defined term, why would we look outside of the statutory definition? Unless it's ambiguous.
Well, I don't think you have to in this case, because I don't think it's ambiguous in this case.
Because you think a house is an enclosure. And so
a house is an enclosure.
But Terminal 4 at Sky Harbor is an enclosure too. Is a dog at large if it's running around off leash in a public building?
It might be, but that's not the case we have here.
No, it's not. But I'm trying to engage on Judge Perkins' question as why would we ever go outside the definition? If an enclosure is an enclosure, then the meat department at Safeway would be an enclosure too, but the dog might be at large and behave very differently.
Does at large have a meaning in common law?
I believe it meant just running loose on the streets where it was not within its own owner's property and not restrained or enclosed on its owner's property. I think to address your question, Judge Swan, I think it may be that there are big enclosures like Sky Harbor Terminal, and perhaps in that situation, if you stay within the statute, this is not a dog at large situation under the statute. It's not strict liability under the statute. But there may be a case of liability if the owner did something negligent, like let its dog off a leash to begin running through the terminal. But that would be looking at the facts of that particular circumstance and what the owner did or did not do under those conditions. But I think in this case it's very clear that we had an enclosure, the house. The dog could not get out onto the public streets, couldn't make its way to the airport and get into the terminal. It's just at home. And
maybe the issue is not whether at large is ambiguous, but whether enclosure is. And if we're considering that, will we then maybe look to another statutorily defined term, kennel, which talks about an enclosed, controlled area inaccessible to other animals in which a person keeps, harbors, or maintains the dogs. Does that inform our definition of enclosure? In which case, a house might not be an enclosure might be more specific to the animals.
I'm not sure where the definition comes from, but
it's in the same statute as the definition of at large.
Okay. Well, if the legislature had intended kennel to be part of the at-large statute, it would have used that statutorily defined term to say the dog must be enclosed within a kennel. And, we have the Damron case. Trying to think of the first name of the... Well, it's a case the Damron case involves a dog that was being groomed. It was at the animal hospital. It was inside the grooming room inside the animal hospital. Then it was inside a tub inside the animal hospital, and then it had a leash attached to it as well. And there was an argument that the dog was at large because it wasn't in its owner's home. But the court said no. The dog is enclosed in the room. It's enclosed in the tub, and it's got a leash on it. So that's not a dog at large. And a dog at home is not a dog at large either, based on any reasonable interpretation of the statute. And statutory interpretation also requires avoiding absurdity. And the arguments that the appellant has made in this situation lead to absurdity because the condition of being at large changes depending upon who moves where inside of a home.
Thank you, counsel. We appreciate your argument today. We'll take this matter under advisement and will issue a decision in due course. We stand adjourned.